You know that feeling? You order something online, maybe from overseas, looks amazing, then it arrives, totally broken, and you just think, who do I even complain to? Where?
Or maybe it's something more personal. Someone gets married abroad, comes back home, and suddenly there's this huge question mark. Is that marriage even legally valid here?
Yeah, exactly. And what about businesses? Say a company you dealt with overseas gets a judgment against them in their own country's courts. Can you actually use that piece of paper, that foreign judgment, to get what you're owed here?
Uh-huh. These aren't just like theoretical legal puzzles anymore, are they? In this connected world we live in, these kinds of legal problems, they just spill across borders constantly.
Right, consumer stuff, really personal family status things, trying to enforce business deals made somewhere else.
It gets complicated really, really fast when you have different countries involved.
It really does.
Yeah.
And all these types of cross-border legal tangles, they fall under this one actually really fascinating area of law. And if you're studying law, well, it's absolutely essential. It's called conflict of laws.
That's the one. And for this deep dive today, we're really lucky to have some excellent source material guiding us. It's educational material provided by the University of London.
Yeah, and we want to be crystal clear up front. This deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And importantly, for all of you listening who might be getting ready for exams, we want to wish you the very, very best of luck. We really hope this session helps solidify things for you.
Definitely. So our mission today is to take this great foundational material and really, unpack the core ideas of conflict of laws.
We want to try and cut through some of that complexity, make sure you grasp the key concepts, feel well informed.
And crucially, feel a bit more prepped to handle problems in this area, right?
Exactly. At its heart, conflict of laws is basically trying to answer three really fundamental questions. If you can kind of keep these three pillars in mind, you're usually on the right track.
Okay, let's lay them out then. The three big questions for conflict of laws are,
Okay, first, whose courts have jurisdiction?
right, meaning, can this court, and we're usually thinking about an English court here, can it actually hear this case at all? Does it even have the power, the legal authority?
That's question one.
Yeah.
Then question two, whose laws are to be used?
Okay, so let's say the court can hear the case, jurisdiction is established. Then what? Which country's actual laws, which legal rules does the court use to decide who's right and who's wrong?
Precisely. That's the big choice of law question.
Got it. And the third one?
Third, can the judgment be enforced?
Ah, okay. So this is different. This is if a court somewhere else has already made a decision, issued a judgment.
Exactly. Under what conditions can that judgment from, say, France or Germany be recognized as valid and actually acted upon, enforced here in England? That's recognition and enforcement.
Okay. Jurisdiction, choice of law, recognition, and enforcement. Got it. Those three, they really are central, aren't they?
Absolutely central. We'll keep coming back to them, you'll see.
So over the next little while, we'll dig deeper into defining conflict of laws properly, look at its own special language and methods. There's some Latin coming up. Be warned.
Huh? Yes, unavoidable, but essential. We'll also grapple with that really key distinction between procedure and substance that can be tricky.
And we have to touch on Brexit, don't we? How that huge shift has shaken things up in certain parts of this field.
We certainly do. It's had a definite impact.
Okay, let's get into it. Starting point. What exactly is conflict of laws? Can we pin that down a bit more?
Right. At its most basic level, conflict of laws is the bit of English law that kicks in whenever a legal issue isn't purely, domestic. It applies when there's what we call a foreign element.
A foreign element, so some kind of link, a connection to a legal system outside England and Wales.
Exactly that. It's that little bit of foreignness that activates the conflict of laws rules. And the source material gives some brilliant examples to show just how wide this goes. It's not just massive international trade disputes.
Like what sort of things?
Well, think about contracts again. Maybe a contract is signed in France, but the goods involved were supposed to end up in Canada. Something goes wrong. They end up suing in England. Suddenly, the English court is dealing with a French contract for delivery to Canada. Foreign elements all over it.
Or accidents, right. You mentioned a car crash in Italy.
Yeah, driver from Paris, driver from England. If the English person sues the French person back here in England, the English court needs rules to handle a tort that happened in Italy between parties from different places.
Okay, makes sense. The source had a really vivid one about a painting, too.
Oh yeah, that's a great illustration. A painting stolen from a gallery in Dresden, Germany. It gets sold in Switzerland. Later, it pops up in London, about to be auctioned. The
Wow.
Dresden Gallery finds out, naturally wants it back. So an English court might have to decide who really owns it. German law, Swiss law, English law. The foreign elements are just jumping out at you.
That really does sound like something from a movie. What about family law examples?
The source uses the example of, say, an English woman who marries in Pakistan. The ceremony is in a form that allows polygamy under Pakistani law. She comes back to England. What's her status here? Is that marriage recognized?
Tricky.
And then, say her husband gets a religious divorce, a talaq, which is valid over there in Pakistan. Does that divorce count for anything here in England? These are really deeply personal questions, but they're triggered by that foreign element, the Pakistani marriage ceremony or divorce.
So contracts, accidents, property disputes, family status, all these everyday things can become conflict of laws problems just because of a link to another country's legal system.
Exactly. And the source material even nudges us, but think about other examples. What else involves foreign elements? Buying stuff online from abroad, obviously, moving countries for work.
Inheriting property somewhere else, having an accident on holiday overseas.
All of them. Potential conflict of laws issues lurking in all those common situations.
Okay, so the foreign element is the trigger. And when that happens, boom, we're back to those three big questions we started with.
Back to the fundamentals. The first one, conflict of laws tackles is, whose courts have jurisdiction? Is this English court legally competent? Does it have the right to even hear this case?
And there are detailed rules for that, but we're sort of parking that for now.
Yeah, for this introduction, we often have to just assume the court does have jurisdiction so we can move on to see what happens next. But knowing those jurisdictional rules is a whole topic in itself.
Okay, assume the English court can hear the case. Step 2.
Step 2 is immediately, whose laws are to be used? The choice of law question. The English court has said, yes, we can hear this dispute. But the dispute has foreign elements. The French contract, the Italian accident. Does the English court apply English law, French law, Italian law?
And conflict of laws rules tell you which one. It guides you to the applicable law.
Exactly. The rules help the court choose the applicable law.
So jurisdiction first, then choice of law. And those two come up every single time there's a foreign element in a new case.
That's what the source emphasizes. Can the court hear it? If yes, what law does it apply? Those are the first two hurdles for any fresh dispute with foreign connections.
Got it. And the third question again was, can the judgment be enforced?
Right. And remember, this one works a bit differently. Recognition and enforcement only comes into play if the case has already been decided by a court in another country.
Ah, right. So you've already got a judgment from, say, an Italian court.
Exactly. And the person you sued is now in England,
Yeah.
maybe has assets here. You need to know if that Italian judgment will be respected, recognized, and enforced by the English courts.
So jurisdiction and choice of law are for the start of a case here with foreign bits. Recognition and enforcement is about giving effect here to a decision already made somewhere else.
You've got it. Think back to those first examples. The faulty computer bought abroad. Suing here. Jurisdiction and choice of law. The validity of the foreign marriage. Jurisdiction and choice of law. That foreign judgment against the company, that's mainly recognition and enforcement.
That framing really helps distinguish them. Okay, one more definitional point the source was keen on. What exactly counts as foreign law? It's not just like non-English law, is it?
No, that's a really crucial point. For conflict of laws purposes, foreign law, or a foreign system of law, means the legal system of any territory that is not the territory where the court hearing the case is located.
So if we're standing in an English court,
Then Scots law is foreign law, because Scotland has its own distinct legal system from England and Wales.
even though it's part of the UK.
Yep. French law is foreign, obviously. German law, South Korean law, they're all foreign systems relative to an English court. The key is different legal system, not just different country. Remembering that Scots law is foreign in this context is a classic point.
Right, Scots law is foreign to an English court. Makes sense. Okay, we know what it is, the key questions it asks. Now, how do you actually do it? What's the process, the methodology, the language?
Okay, so the source lays out this structured approach. Step 1, as we said, assume jurisdiction for now. Step 2 is absolutely critical. It's called characterization, or sometimes classification.
Characterization. Sounds like working out what kind of legal problem you're actually looking at.
That's exactly it. You have to figure out the juridical nature of the question. In simple terms, what box does this problem fit into legally? Is it fundamentally about a breach of contract? Or is it a tort, like negligence? Is the core issue about someone's legal ability, their capacity to get married? Or is it just about whether the wedding ceremony itself followed the right rules, the formalities?
So you're labeling the problem using English legal categories, even if the events happen somewhere else under a different legal system.
Precisely. You characterize or classify the issue using the concepts familiar to the lex for the law of the English court. And you have to do this first, because the category you put it in determines which specific choice of law rule you need to look up and apply. You can't find the right rule until you've correctly labeled the legal question.
Okay, step one. Characterize the issue using English legal concepts. Then what?
Once you've characterized the issue, let's say you've decided it's a capacity to marry question. The court then needs to select the legal system that governs that specific question, and that governing law has a name. It's called the lex causae.
Lex causae. Okay, another Latin term. This is the important one, right?
Absolutely. Lex causae. Get used to saying it. It literally means the law of the cause, but think of it as the law applicable to the specific dispute, or even better, the law applicable to the specific legal issue you just characterized.
So if we characterize the issue as breach of contract, the lex causae is the law that governs that contract. If it was formal validity of marriage, the lex causae is the law governing the ceremony rules.
You got it. The lex causae is the law that provides the answer to the specific legal question identified through characterization.
Okay, lex causae, the applicable law for the issue. How does the court find the lex causae? How does it choose between, say, French law or Italian law or English law?
That's where the next piece of jargon comes in. The connecting factor.
A connecting factor.
Yes, the connecting factor is the specific element in the facts of the case that links the legal problem to a particular legal system. It points the way. It could be a place like where property is located or where an event happened, or it could be a personal characteristic like someone's domicile or their nationality.
So the choice of law rule for a particular issue will contain a connecting factor.
Exactly. The rule will say something like, for issue X characterization, the governing law, lex causae, is the law indicated by connecting factor Y.
Right. Characterize the issue, find the rule, identify the connecting factor in the facts, and that points you to the lex causae. Makes sense to process. Okay, let's run through some of the main connecting factors the source mentions. More Latin, I presume.
You presume correctly. And these are fundamental, so it's worth repeating them.
Yeah.
For questions about personal status, things like capacity to marry, succession rights in England, the traditional main connecting factor is the lex domicili.
Lex domicili.
The law of the person's domicile. Now, domicile is a technical legal concept in English law. It's not just where you live. It's not your nationality. It's your legal home. And English law uses this lex domicili as the key personal link.
But that's not universal. Other countries use something else.
Many do, especially countries with a civil law tradition like France, Germany, Italy. They often use the lex patriae,
Lex patria.
the law of the person's nationality. So a French court looking at capacity might apply the law of the person's citizenship, whereas an English court looks to their lex domicili. Though it's worth noting, the source does say English law is increasingly using residence, especially habitual residence, as a connecting factor in some areas, often because of international treaties or laws derived from the EU era.
Okay, so lex domicili, domicile is key in England, lex patriae nationality, common elsewhere, and residence is becoming more important here too. What about connecting factors for specific types of legal acts, like getting married?
Right. If the question isn't about whether the people had capacity to marry, but about the ceremony itself, did they do the paperwork right, was the officiant authorized, etc., the formal validity, then the usual connecting factor is the lex loci celebrationis.
Lex loci celebrationis, bit of a mouthful.
It is. It means the law of the place where the marriage was celebrated. Did the ceremony comply with the local rules where it happened? Lex loci celebrationis.
Okay. And what about the law of the court that's actually hearing the case? Is that a connecting factor too?
Oh, absolutely. A very important one. That's the lex fore.
Lex fore.
The law of the forum, the law of the court, hearing the case. As we'll discuss very soon, the lex fore is king when it comes to matters of procedure.
Right, that procedure versus substance thing. Okay, nearly there. Contracts. What's the connecting factor for them?
For contracts, the governing law is often referred to as the lex contractus.
Lex intractus.
The source points out that under the older common law rules, this was often called the proper law of the contract. Under the more modern regulations, which are now part of UK law, the term applicable law is frequently used. So lex contractus, proper law, applicable law, they all point to the same thing. the law that governs the substance of the contract.
And torts, like that Italian car crash example.
For torts or non-contractual obligations, the connecting factor very often points towards the lex loci delicti,
Lex loci delicti.
the law of the place where the tort, the wrongful act was committed. Where did the harmful event actually occur? Lex loci delicti.
Okay. Any others we really need to know?
A few more useful ones are mentioned. Lex loci actus, the law of the place where a specific legal act or transaction was done. Lex situs. This is important for property, especially immovable property like land. It's the law of the place where the property is situated. Lex situs.
So for a house, it's the law of the place where the house physically is.
Exactly. Then there's lex incorporationis, the law of the place where a company was incorporated, relevant for things like a company's powers or transferring its shares. And finally, lex protectionis, used in intellectual property. It's the law of the country under which protection for that IP right, like a patent or trademark, is granted.
Wow. Okay, that's quite a list. Let's recap those. Lex causae, the applicable law. Lex domicilii, law of domicile. Lex patriae, law of nationality. Lex loci celebrationis, law of place of marriage. Lex fori, law of the court. Lex contractus, law of the contract. Lex loci delicti, law of place of tort. Lex loci actus, law of place of act. Lex situs, law of place of property. Lex incorporationis, law of place of incorporation. And lex protectionis, law of place of IP protection.
It really shows you need this specific vocabulary, doesn't it? Each term acts like a signpost.
It does. And the source had a really good example to show how different connecting factors can apply to different parts of the same problem, right? The intestacy one.
Yes, that's a classic for illustrating the method. Imagine a British citizen. They die without a will and testate. At the time they died, their legal domicile was in Italy.
Okay. British national Italian domicile.
And they own some assets, let's say shares in an English company and also a house located in Scotland.
Right. So multiple jurisdictions involved: UK citizenship, Italian domicile, English shares, Scottish house.
Perfect setup. Now, conflict of laws often draws a distinction between movable property, like shares, cash, furniture, and immovable property, land and buildings.
Movables and immovables. Okay.
For distributing movables, when someone dies intestate, the general English conflict rule points to the law of the deceased's domicile at the time of death. That's the lex domicilii.
So for the shares in the English company, which are movables, we look to the lex domicilii.
Exactly. The deceased was domiciled in Italy. So Italian law, lex domicilii, would govern how those English shares are distributed among the heirs.
Interesting. Italian law decides what happens to shares in an English company in this case.
Correct. Now, what about the house in Scotland? That's immovable property.
Immovable, so a different rule applies.
Yes. For immovables, the governing law for succession is generally the lex situs.
Lex situs, the law of the place where the property is situated.
Spot on. The house is in Scotland. Scotland has its own legal system. So, Scotch law, as the lex situs, would determine who inherits the house in Scotland.
That example is brilliant. It shows it all working. You characterize the asset's movable shares, immovable house. You apply the right connecting factor for succession to each type, lex domicilii for movables, lex situs for immovables, and you end up with different lex causae for different assets belonging to the same person. Italian law for the shares, Scots law for the house. You wouldn't guess that without these rules.
It really highlights why you need this structured approach. So just to recap the method, spot the foreign element. Characterize the legal issue using lex fora concepts. Find the correct choice of law rule for that issue. Apply the connecting factors stated in that rule to the facts, and that points you to the lex causae.
Characterize, connect, find the lex causae.
Got it. Right, now for that big distinction you flagged earlier, procedure versus substance, this sounds like where the lex farti really flexes its muscles.
It absolutely does. This is arguably one of the most fundamental dividing lines in the whole subject. We've just seen who we find the lex causae, the foreign law that should govern the substance of the issue. But there's a huge exception to applying that foreign law.
And that exception is procedure.
Exactly. The principle is stark and simple. All matters classified as procedure are governed exclusively by the lex fori.
The lex fori. So the law of the court hearing the case. If it's an English court, English procedural rules apply. End of story.
Pretty much. If an English court is hearing a case, any question that is deemed procedural is decided according to English law, regardless of what the lex causae, the foreign law governing the main issue, might say about it. If a foreign rule from the lex causae clashes with an English procedural rule, the English rule wins. The lex fori is paramount for procedure. Okay. Substance is generally governed by the lex causae, but procedure is always governed by the lex fori. That feels like a massive carve-out. And the tricky bit, I suppose, as the source hinted, is deciding whether a particular rule is procedural or substantive.
That is precisely the difficulty. The characterization problem rears its head again. Is this specific rule about how you bring your claim, how you prove it, what remedy you can get? That sounds like procedure. Or is the rule about whether you have a right or obligation in the first place? That sounds like substance.
And English law has views on which is which.
Yes, for many common issues, the classification is reasonably well settled, although gray areas remain. Understanding which issues English law treats as procedural is essential. Let's go through the main examples the source gives.
Okay, what's first on the list of things considered procedural?
The nature of the remedy you can get from the court. An English court grants English remedies. It applies its own menu of available remedies, lex fori. It generally won't try to grant some specific, perhaps unique remedy that might be available under the foreign lex causae.
But isn't that a bit rough? What if the whole point of the foreign right is tied up with a very specific foreign remedy? Does the English court just ignore that?
Well, there's a crucial qualification here, and it brings us to a very important case. Francis v. Argenti.
Francis v. Argenti, 1960.
Okay, yes, Francis v. Argenti. This case basically says, yes, the English court applies its own remedies, lex fori procedural rule. However, it might refuse to grant any remedy if the foreign right, under the lex causae, is so fundamentally different in nature, or perhaps so dependent on the discretion of the foreign court system, that trying to enforce it with a standard English remedy would completely change or distort the original right.
Okay, that makes sense. It's like trying to fit a square peg in a round hole. Let's use that self-assessment question from the source to see how this works. F and D are domiciled in country X. Under the law of X, the lex causae, F is legally obliged to provide a dowry for his daughter, D, but the amount isn't fixed. It's up to the court in X to decide based on F's wealth and D's conduct. D then tries to sue F in England to get this dowry. What's the likely problem?
Okay, this maps really well onto Francis v. Argenti. The substantive right to a dowry comes from the lex causae, the law of X. No problem there. But the nature of that right under X law is highly discretionary. It needs a court in X to weigh up specific factors, wealth behavior, to arrive at an amount.
Right, it's not like a simple debt.
Exactly. So D comes to the English court, lex fori, asking for an English remedy, probably an order for payment. But the English court looks at this and thinks, hang on, our standard remedies, like ordering a specific sum, don't really match this highly discretionary right from country X. We don't have the machinery or the cultural context to assess dowries based on wealth and behavior according to X's law.
So trying to give an English remedy would fundamentally change the nature of the right D actually has under the law of X.
Precisely. It would distort the right. Therefore, the English court, applying its lex fori procedural rules about the remedies it can grant, would likely conclude it can't provide a suitable remedy here without altering the substance of the foreign right. So D's claim in England is likely to fail based on the principle in Francis v. Argenti. The remedy issue, being procedural, becomes decisive.
That illustrates the Francis v. Argenti point perfectly. The procedural limitation on remedies effectively blocks the enforcement of the substantive right. Okay, what else is procedural?
The method of enforcing a judgment once you've got one. English law, lex fori, determines things like which of the defendant's assets can be seized, in what order, and how the sale process works.
And who can actually sue or be sued? The parties.
Generally, yes. The rules about who can be a party to litigation are considered procedural and governed by the lex fori. The source gives us two interesting cases here. First, Banque Internationale de Commerce de Petrograd v. Gucasso. Banque Internationale de Commerce de Petrograd v. Gucasso, 1923. This case established that under English procedural rules, lex fori, you simply cannot start legal proceedings in the name of someone who is already dead, even if the foreign lex causae might theoretically allow it somehow. English procedure dictates who has standing to be a litigant.
Okay, so English rules about who can sue are firm. But does English procedure recognize entities created under foreign law, like foreign companies?
Yes, it generally does, if that entity has legal personality under its own law, and that's shown by the contrasting case. Bumper Development Corps v. Commissioner of Police for the Metropolis.
Bumper Development Corps v. Commissioner of Police for the Metropolis.
1991.
Right. This involved a claim concerning a stolen Hindu statue. The claimant was an Indian temple. The source notes quite vividly that the temple itself was perhaps physically just little more than a pile of stones.
But, crucially, under Indian law, its lex causae for existence, the temple was recognized as a legal entity. It could own property, you could sue and be sued. The English court, applying its procedural rules, lex fori, on who can be a party, respected the legal personality granted by the foreign law. It allowed the temple, despite being a pile of stones, to be a party to the English proceedings.
That's a fantastic contrast. So the lex fori controls the process of who can litigate, but it looks to the lex causae to determine if a foreign entity exists as a legal person capable of litigating.
Exactly. It shows the interplay. What about evidence?
Ah, rules of evidence. I bet they're procedural.
You bet correctly. Firmly procedural, governed by the lex fori. This covers a whole range of things. Is a witness competent to testify? Does a particular agreement need to be in writing to be proved? How much evidence is needed to meet the burden of proof? Is certain evidence admissible or inadmissible, like hearsay rules, all decided by English rules in an English court?
Okay, evidence is lex fori. What about legal presumptions? The source said this was a bit more complex.
It can be. Some presumptions are definitely rules of substance, not procedure. The classic example is an irrebuttable presumption of law, like the one in Section 184 of the Law of Property Act, 1925.
Section 184 Law of Property Act, 1925. That's the Comorientis rule, right? If two people die and you can't tell who died first, the younger is presumed to have survived the elder.
That's the one. It's treated as a rule of substantive law because it directly affects who inherits property. And the case that confirms this characterization as substance is Recone.
Recone, 1945.
Yes, Recone. Remember that for presumptions of survivorship. Many rebuttable presumptions are also often treated as substance, like the presumption of a resulting trust in property law. But, as the source rightly flags, there's still some debate about others, like the presumption of marriage validity or the presumption of legitimacy. Are they procedure, part of proving the case, or substance, part of the underlying status? It's not always clear-cut.
Let's use that other self-assessment question to test the Recone principle. M and her daughter D are both domiciled in country Y. M leaves her movable property, like money shares, to D in her will. They are refugees living in England and tragically died together in a car crash here. It's impossible to say who died first. Now, the law of country Y, their lex domicili, so the lex causae for succession of movables, has a rule saying they are presumed to have died simultaneously. But English law, lex fori, has 184 saying the older person, M, is presumed to have died first. Which presumption does the English court apply?
Okay, this is a direct application of the Recone reasoning. The issue is succession to movable property. The connecting factor is domicile, lex domicili, which points to the law of country Y as the lex causae. So Y law governs the substance of the inheritance. The crucial question is the rule about who died first the presumption, procedural or substantive?
And Recone said these survivorship presumptions are substantive.
Exactly. Because S-184 is a rule of substance under English law, lex fori, the English court characterizes the equivalent rule in the lex causae, Y law's presumption of simultaneous death, also as substantive. When there's a conflict between substantive rules, the lex causae prevails over the lex fori.
So the English court ignores its own S.184 rule here.
Yes, it applies the substantive rule from the lex causae. Since the law of Y says they died simultaneously, the English court will apply that presumption to decide how M's property is distributed. The foreign substantive rule wins.
That really clarifies how the characterization as substance in Recone works. Okay, last big procedural area, statutes of limitations, time limits for suing.
Right, and this is an area where there's been a really significant change in English law. Historically, at common law, limitation periods were treated as purely procedural. Meaning it didn't matter what the time limit was under the foreign law that governed the actual dispute, the lex causae. An English court hearing the case would always apply the English limitation period, lex fori.
Always the English time limit, regardless.
That was the old rule. But it was seen as problematic, sometimes allowing claims that were long dead under their own law or barring claims that were still valid there. So Parliament stepped in. The Foreign Limitation Periods Act, 1984.
The Foreign Limitation Periods Act, 1984.
That's right.
A key piece of legislation.
Absolutely fundamental for this topic. This act completely flipped the common law position. It basically said that limitation periods are now to be treated as matters of substance, not procedure.
Wow. So now the English court looks at the foreign time limit.
Yes. Under the 1984 Act, the general rule is that the English court must apply the limitation period prescribed by the lex causae, the law that governs the underlying substantive issue, like the contract or the tort.
So if French law governs the contract, you apply the French time limit for suing on that contract, even in an English court.
That's the starting point now. Yes,
Yeah.
It's a major change. However, There's a crucial safety valve built into the Act. It's in Section 2, subsection 1.
Section 2(1) of the Foreign Limitation Periods Act, 1984.
This section gives the English court a discretion. It says the court can refuse to apply the foreign limitation period dictated by the lex causae if applying that foreign period would conflict with English public policy. Essentially, if it would be really unjust or unconscionable in the circumstances.
Ah, a public policy escape hatch. And if the court does disapply the foreign period on policy grounds,
Then the English limitation period, lex fori, applies instead. So it's substance first. But with the lex fori fallback, if applying the foreign rule would be contrary to fundamental English notions of justice.
is there a case that shows this public policy override being used?
Yes, the key one mentioned in the source is Jones v. Trollope Call's cementation.
Jones v. Trollope Call's cementation. From the Times, 1990.
In that case, the foreign lex causae had a very short limitation period, just 1 year. The claimant had been seriously injured and spent a large chunk of that year in hospital. They might also have been misled about whether a claim was being pursued for them.
So they barely had time to act.
Exactly. The English court looked at the situation and said, effectively, applying this super short 1-year foreign limit, given that the claimant was incapacitated for much of it, would be fundamentally unfair. It conflicts with our public policy. So they used Section 2(1) of the Foreign Limitation Periods Act, 1984, set aside the 1-year foreign limit, and applied the normal, longer English limitation period instead. The claim could proceed.
That's a really clear example of the safety net in action. Let's try the last self-assessment question on this. A gets injured in a road accident in country Z due to B-Co's negligence. A is in hospital for 7 months recovering. Eventually, A sues B-Co in England. The claim is started within the standard English 3-year limit for negligence claims. But after the 1-year limitation period under the law of country Z, which is the lex causae, the lex loci delicti, has already run out. Which time limit applies?
Okay, perfect scenario for the 1984 Act. The underlying tort happened in Z, so Z law is the lex causae. Under the Foreign Limitation Periods Act 1984, limitation is substance, so prima facie, the English court should apply Z's 1-year limit. But look at the facts. A was in hospital for 7 months out of that 1-year period. This immediately brings Section 2(1) and the public policy consideration into play. It's very similar to Jones v. Trollope Call cementation.
Because applying a 1-year limit when the claimant was unable to act for 7 months of it seems really unfair.
Exactly. An English court would likely find that enforcing Z's 1-year limit in these specific circumstances would be contrary to English public policy. Therefore, the court would almost certainly exercise its discretion under Section 2(1) of the Foreign Limitation Periods Act 1984, just apply the 1-year limit from Z law and apply the English 3-year limit instead. So A's claim would be allowed to continue.
That pulls it all together. The 1984 Act makes it substantive, but Section 2(1) provides that crucial public policy override demonstrated in Jones v. Trollope Call's cementation, allowing the lex fori limit to apply when fairness demands it.
Precisely. And mastering this whole procedure-substance distinction, knowing where common issues like remedies, parties, evidence, and especially limitation periods fall, and remembering the impact of the Foreign Limitation Periods Act 1984, and those key cases like Francis v. Argenti, Banque Internationale, Bumper Development, Recon, and Jones v. Trollope Calls is absolutely vital. It's fundamental for understanding conflict of laws and definitely for tackling exam questions effectively.
Speaking of tackling the subject, the source material also offers some really helpful pointers on resources for further study, doesn't it?
It does. And honestly, you can't really get to grips with conflict of laws without digging into the textbooks and, crucially, the cases themselves. The source recommends a couple of core textbooks to get you started. Clarkson Hill is often suggested as a good, straightforward entry point.
Clarkson and Hill's Conflict of Laws. Accessible start. Okay.
Then, perhaps the best-known student text is Cheshire, North and Fawcett on private international law.
Cheshire, North and Fawcett. Sounds more heavyweight.
It is. The source describes it as much more detailed, very analytical, but maybe a bit daunting for absolute beginners. So perhaps starting with Clarkson and Hill, or another one we'll mention, and then moving on to Cheshire once you've got the basic framework is a good strategy.
What other options are mentioned?
Briggs on the Conflict of Laws is noted as being shorter, quite thoughtful, and particularly good for revision, maybe after you've read a main text.
Briggs. Good for consolidation.
Hartley's book, International Commercial Litigation, gets a mention for being especially interesting on jurisdiction issues, particularly around the old EU Brussels regulation.
Hartley. Focus on jurisdiction.
And Collier's Conflict of Laws is suggested as another student-friendly alternative to Clarkson and Hill. It's described as having a lively style, though maybe not quite as exhaustive as some others.
Collier, lively, student-friendly, seems like a good range of choices.
And then there's the Practitioner's Bible, Dicey, Morrison, Collins.
Dicey, Morrison, Collins, The Conflict of Laws, the definitive work.
Pretty much. It's incredibly detailed, cites almost everything, the go-to reference for lawyers in practice. Very expensive to buy, but essential to know how to use in a library.
Beyond the textbooks, though, the source really hammers home the need to read the actual cases.
Absolutely critical. You see, the rules we've been talking about actually being applied, argued over, interpreted by judges. Don't just rely on case summaries. Try to read key passages from the judgments themselves. Ask yourself, how did the judge reach this decision? What principles were they weighing up? What underlying policies might be at play?
Because the answers aren't always black and white in this area, are they?
Often not. Different textbooks might even favor different arguments on tricky points. The source encourages that critical engagement. Weigh up these arguments and see what conclusions you come to. Think for yourself.
Good advice. And how do you keep up with new cases?
Well, new decisions are always coming out. The source suggests keeping an eye on the main law reports series, like Lloyd's Law Reports, especially for commercial stuff, the All England Reports, and the Weekly Law Reports.
Excellent tips for digging deeper. Okay, final big topic. Brexit. This must have had a major impact on conflict of laws in the UK.
Oh, undoubtedly. The UK leaving the EU has caused significant changes in some core areas of English conflict of laws. Specifically, those three areas we keep coming back to: choice of applicable law, court jurisdiction, and the recognition and enforcement of foreign judgments.
So the big three questions are all affected.
They are the main ones. It's worth pointing out, though, some areas like international arbitration law and practice in the UK haven't really been directly affected by Brexit in the same way.
Okay, focusing on the affected areas then. Let's take choice of law first. What was the deal before Brexit?
Before Brexit, English courts, like courts across the EU, directly applied specific EU regulations for choice of law. The key ones were the Rome I regulation for contractual obligations
Grand contract.
and the Rome II regulation for non-contractual obligations, like torts, unjust enrichment, that sort of thing.
Rome 2 for torts, etc. Okay, so those regulations set the rules.
They did. Very detailed rules. Now, post-Brexit, the first thing to know is that under the withdrawal agreement, those Rome and Rome II regulations still apply in UK courts, but only to contracts made or harmful events that occurred before the end of the transition period. That date was 31 December 2020.
Right, December 31st, 2020. So old cases use the old EU rules directly. What about new stuff? Contracts made or torts happening from January 1st, 2021 onwards.
Okay, for these new cases, the source indicates that the practical situation regarding choice of law probably hasn't changed all that much.
Oh, why is that?
It's mainly because of a feature within the Rome and Rome II regulations themselves called universal application. This means that even an EU court applying these rules will determine the applicable law according to the regulations connecting factors, and it will apply that law even if it turns out to be the law of a non-EU country, a third state.
So after Brexit, an Italian court using Rome, I could still end up applying English law if the contract points that way.
Generally, yes, that's the idea behind universal application. And looking at it from the UK side, the UK government essentially copied the Rome II regulations into UK domestic law. They are now retained EU law under the Withdrawal Act, with some minor tweaks to make them work just within the UK context.
So UK courts are applying basically the same set of rules before, just under a different legal label, retained EU law.
Exactly. So both EU courts and UK courts are, by and large, still applying the same substantive choice of law rules derived from Rome II. The result is that choice of law clauses pointing to English law, for example, should continue to be respected across the EU, and vice versa. Choice of law seems relatively stable, despite the legal mechanics changing.
Okay, that's clearer. Choice of law, not drastically different in practice, but jurisdiction, I suspect that's a different story.
You suspect correctly. Jurisdiction has been significantly more disrupted. Before Brexit, jurisdiction between the UK and EFTA states was largely governed by harmonized EU rules, principally the Brussels I recast regulation and also the Lugano Convention for dealings with Switzerland, Norway, and Iceland.
Brussels I recast and the Lugano Convention, key instruments.
Very key. The withdrawal agreement did provide some transitional protection. Brussels I recast continues to apply, but only to UK court proceedings that were started before the end of 2020.
Okay, cases started before the deadline get the old rules. What about Lugano?
The Lugano Convention transition was a bit messier. The withdrawal agreement didn't have quite the same clear provisions, and the position regarding the other Lugano states, Norway, Iceland, Switzerland, was less certain for cases pending at the deadline.
Right. And for brand new cases, proceedings started from January 1st, 2021 onwards. What rules apply then between the UK and EU Lugano
Well,
countries?
basically, from 1st January 2021, the Brussels I recast regulation and the Lugano Convention generally stopped applying to the UK for new cases.
Stopped completely. Why?
Because these systems are built entirely on mutual reciprocity and trust between the participating states. They agree to follow the same rules and respect each other's courts. When the UK left the EU framework, that foundation of reciprocity for these specific treaty-based systems largely fell away for new disputes.
So, those streamlined, predictable rules for deciding jurisdiction involving EU Lugano parties, they're just gone for new cases?
Largely, yes. The UK is now treated much like any other third country from the EU perspective for jurisdiction purposes under those instruments. One possibility was for the UK to rejoin the Lugano Convention, not as an EU member, but in its own right.
Did the UK try to do that?
Yes, the UK formally applied to accede to Lugano. But here's the catch. Accession requires unanimous consent from all the existing parties. That includes the EU itself. And the source explicitly states that the European Commission formally recommended that the EU should object to the UK's accession.
Ouch. So that route looks blocked for now.
It seems very difficult, yes. The UK's membership of Lugano remains uncertain, likely off the table unless the political winds change significantly.
So, if Brussels and Lugano are largely out for new cases, what takes their place for UK-EU Lugano disputes? Is it back to older, more complex rules?
To a large extent, yes. It means relying more on the UK's own domestic rules on jurisdiction, common law rules, service out of the jurisdiction, etc., which can be more complex and less predictable. Or relying on other international agreements where they apply. And there's one important convention the UK has formally joined in its own right from 1st January 2021.
Which one is that?
The Hague Choice of Court Convention 2005.
The Hague Choice of Court Convention 2005. Okay, what does that do?
This convention is specifically about upholding exclusive choice of court agreements in international commercial contracts. If parties from contracting states agree in their contract that any disputes must be heard exclusively by the courts of a particular contracting state, say England, then the courts of other contracting states generally have to respect that choice. They should decline jurisdiction if sued there, and they should recognize and enforce judgments given by the chosen court.
So it provides some certainty, but only if you have an exclusive jurisdiction clause in your contract.
Exactly. It's very useful for that specific scenario, giving teeth to exclusive clauses. However, the source points out there's still a bit of lingering debate about its exact scope post-Brexit. Does it apply to exclusive clauses agreed before January 1st, 2021, when the UK was party via the EU since October 2015? Or only to clauses agreed on or after January 1st, 2021, when the UK joined in its own right? That lack of complete clarity adds to the post-Brexit complexity.
So jurisdiction. Definitely more complicated than choice of law. Loss of Brussels-Lugano for new cases, uncertainty over Lugano reaccession, increased reliance on domestic rules, and the Hague 2005 Convention providing some help, but only for exclusive clauses, and even then with some debate.
That's a pretty accurate summary, a significant shift. And logically, this flows directly into the third question, enforcement of judgments.
Because if jurisdiction is harder to establish under predictable rules, enforcing the resulting judgment must also be harder.
Precisely. Before Brexit, Brussels recast and Lugano provided relatively smooth pathways for getting judgments recognized and enforced across member states. The withdrawal agreement preserved this for judgments resulting from proceedings started before the end of 2020 under Brussels recast. Again, the Lugano position was less clear-cut.
But for judgments from UK cases started from January 1st, 2021 onwards, how easy is it to enforce those in the EU or Lugano states now?
Generally, it's become more difficult and complex. You can no longer rely on the almost automatic recognition under Brussels I or Lugano. Instead, you typically have to fall back on the domestic enforcement laws of the specific EU or Lugano country where you want to enforce the UK judgment. This might involve more hurdles, potentially re-examining parts of the case, more costs, and less certainty.
So potentially a much bigger headache. Does the Hague Convention help with enforcement like it does with jurisdiction clauses?
It offers some help, yes, but again, it's limited compared to the old regime. The Hague Choice of Court Convention 2005 does require contracting states to recognize and enforce judgments given by a court that was designated in an exclusive choice of court agreement falling under the convention.
So if you have that exclusive clause pointing to English courts, got your English judgment, the Hague Convention should help you enforce it in, say, France or Germany, as they are also parties.
That's the principle, yes. But remember the limitations. It only applies if there was an exclusive jurisdiction clause in the first place, and there's still that ongoing debate about whether it covers clauses agreed before 2021.
Mm-hmm.
It's not a blanket replacement for the broad enforcement mechanisms under Brussels I recast. It helps in specific commercial cases with exclusive clauses, but doesn't solve the enforcement issue for many other types of judgments.
Okay, so summing up the Brexit impact. Choice of law seems relatively stable in practice due to retained law and universal application. But jurisdiction and enforcement have seen major changes for new cases involving EU Lugano states, with the loss of Brussels Lugano rules, reliance shifting to domestic law, and the more limited Hague 2005 Convention for exclusive clauses, creating more complexity and uncertainty overall.
That captures the essence of it well. It's an area where the practical consequences are still being worked through by lawyers and businesses, and the legal position might continue to evolve.
Right. Well, we have certainly covered a huge amount of ground in this deep dive.
We really have. We've explored the absolute fundamentals of conflict of laws, using that excellent University of London material as our guide. We kept coming back to those three vital questions: jurisdiction, choice of law, recognition, and enforcement.
We unpacked the method, characterization, using the lex fori, finding the connecting factor, leading us to the lex causae, and we got comfortable with that essential Latin vocabulary lex domicilia, lex situs, lex fori, and all the rest.
We then spent significant time on that crucial procedure versus substance distinction, understanding why the lex fori governs procedure, and looking at how English law classifies key issues like remedies, Frances v. Argenti, parties, Banque Internationale pour Development, evidence, presumptions, recon, and especially limitation periods. Remember the big change brought by the Foreign Limitation Periods Act 1984 and the public policy exception shown in Jones v. Trollope-Coll's cementation?
And finally, we tackled the significant practical impact of Brexit, seeing how it's changed the rules of the game for choice of law, jurisdiction, and enforcement, particularly in the context of the EU and Lugano states, bringing in the Hague 2005 Convention, but also leaving areas of uncertainty.
And thinking about the learning outcomes mentioned in the source material, hopefully after listening to this, you feel much better placed to, explain those three core questions, define foreign law accurately in this context, use the specific language and concepts correctly, and confidently identify which issues are likely procedural versus substantive in an English court.
Absolutely. Getting these foundations solid, the questions, the terms, the method, the key cases and statutes, it really is essential for studying the subject properly and, of course, for performing well in any exams.
So, maybe as a final thought, something for you to mull over, go back to those self-assessment questions we discussed. The dowry claim. Using Frances v. Argenti, can you really articulate why the English court would struggle to grant a remedy? The simultaneous death scenario. Drawing on recon, explain precisely why the foreign presumption, lex causae, overrides the English one, lex fori, and that limitation period problem. Using the Foreign Limitation Periods Act 1984 and Jones v. Trollope-Coll's, construct the argument for applying the English time limit based on public policy.
Yeah, really work through them using the framework. Characterize, find the lex causae, consider procedure versus substance, apply the relevant cases or acts. That active thinking is where the learning really sticks.
And just to reiterate, this deep dive has been purely for educational purposes, based on material kindly made available by the University of London, and it's been brought to you by Sinorbit Academy, Sri Lanka.
And truly, for all students listening who are gearing up for exams, we genuinely wish you the very best of luck. You've done the hard work, now go in there and apply these principles. Keep digging into the cases and the concepts.
Thanks so much for joining us for this deep dive into the foundations of conflict of laws.